Hello, welcome to this session on some changes to the Commission's regulations about consultation and notification requirements, as well as changes to our service regulation. The Commission's work is guided by a vision of safe and responsible energy resource development for British Columbia. We have a mission to provide British Columbia with regulatory excellence in responsible energy resource development by protecting public safety, safeguarding the environment, and respecting those individuals and communities who are affected. Many of the changes I'll be discussing today were made in light of that mission to respect individuals and communities who are affected by oil and gas activity. Note that this webinar focuses on changes to the current requirements and assumes that you, the listener, are familiar with the existing requirements for consultation, notification, and service. If you're not, or if you are but would like a refresher, you can check out the webinar titled Consultation and Notification that is located on the Commission's webpage. The specific location and address of that basic webinar is provided on slide 29 of this presentation. So now I'll run through the agenda. We're focusing on why we brought in the new requirements for consultation and notification regulation, or RCNR. And we're just again going to focus on the highlights and key changes of that regulation as well as the service regulation. All of these changes will come into force on June 1st. So I'm going to spend a little bit of time talking about timeline transitions for applications that are submitted on or around or just after June 1st. We'll also discuss the definition of major amendment and how that ties into requirements for consultation and notification for amendments, and provide some information on guidance and documentation and where you can seek further information after this webinar if you have questions. So why did we make the changes? The old regulation was hard to follow and the new regulation is clearer. So we started out with a basic list of not that many changes we were going to make to the old consultation notification regulation, but heard from the provincial lawyers who draft these regulations that they felt we should really be tidying up the language and making it easier to follow. So we've also given the regulation a new name, Requirements for Consultation and Notification Regulation, just so it's easy not to get mixed up between which one applies in what circumstance. The changes that we're making, many of them are meant to be responsive to landowner interests. Specifically, there's a few changes that are intended to reduce the amount of nuisance notifications that a landowner or local government might receive, so that the invitations to consult or notifications that you get are more manageable and more relevant. There's been quite a few changes to who would be consulted or notified in certain circumstances, and that's meant to reflect who is most likely to be affected. We also made changes to the service regulation that are responsive to feedback we've heard from landowners and from Indigenous groups, specifically around the deemed mail delivery timeline for the Northeast, which we understand is quite a bit longer than 5 days. So key changes are around who or who not to consult or notify, where to consult or notify, what the triggers are for consultation or notification, what information to be providing in the consultation notification letters, and when does the response period start and end, and what happens at what time. So addressing the who first. There have been some changes to who will be consulted or notified. Those are specifically around who is considered to be rights holders. So we've included now OGA permit holders, First Nations woodland licenses and timber licenses under the Forest Act, as well as holders of a permit, lease, or well authorization under the Geothermal Resources Act. If a community watershed designated under the Oil and Gas Activities Act is within a notification distance, then a Water Sustainability Act licensee will receive notification, as will a construction or operating permittee under the Drinking Water Protection Act. There's also some bodies that will no longer be getting consulted or notified in certain circumstances. For example, a local authority will no longer need to be consulted or notified if an official community plan map designation is within the notification distance, if a community watershed is located within the notification distance, or if an applicant has proposed a pressure regulating station on its own land. Applicants will only need to consult or notify a landowner on whose land a pipe will be located in an application revision that includes a non-sour pipeline. So other landowners, neighboring landowners, wouldn't get consulted if an application is revised to include a non-sour pipeline. Okay, there's been a few changes to where to consult or notify. This slide shows the consultation and notification distances in the new regulation. For the most part, they're the same as they used to be, but there are a few instances where the distance has gotten smaller. Compressor and pump station distances have gone down from 3,300 meters to either 1,300 or 1,800 meters or 1,000 or 1,500 meters, depending on the size of the facility area. So it'll be governed by items 2 and 3 in this chart here. The distances for LNG facilities or gas plants that have already gone through an environmental assessment has also been lowered from 3,300 meters down to distance within item 2 or 3. And that's because the EA process already has a very robust public engagement process. So we're thinking to avoid more nuisance notifications. Once it's been through EA, it's a lower radius where consultation notification will occur. Finally, the 9-well trigger for moving a site into a larger consultation or notification distance has been removed. Now it's just the size of the well site rather than the amount of wells on the site that will determine which distance is applicable for consultation and notification. And that's as between items 4 and 5 on this chart. Now we'll turn to the changes in what triggers consultation and notification. A water pipeline in a highway right-of-way, application revisions including a water well, application revisions that include a sour pipeline, and application revisions that change a facility's capacity enough to change its class. Similarly, if an application revision adds the installation of new storage tanks, compressors, dehydrators, flare stacks, generators or stabilizers, various gas processing equipment for fractionation, etc., or the installation of any new major equipment that may significantly increase the amount or duration of the noise, dust, light, odors, or anticipated vehicle traffic on oil and gas roads within the consultation distance, those type of changes would also restart consultation and notification. Permit amendments could also trigger consultation and notification if the Commission requires it under Section 31.5 of the Oil and Gas Activities Act. This gives decision makers more flexibility than they used to have to require consultation and notification for an amendment application on an existing permit. The definition of major amendment that was in the old consultation notification regulation has been completely removed from it. And that's to make our regulation more consistent with OGA section 31.5, where it really is meant to be a decision by the decision maker on an individual application as to whether consultation and notification is required in relation to that amendment. There is no change to other OGA and Water Sustainability Act consultation and notification requirements on amendments, however. So the removal of the definition of major amendment does not change permit holders' obligation to provide notice to the landowner of the land where the operating area is. So under OGA, before submitting an application for an amendment to a permit, the permit holder must still provide notice to the landowner of the land on which the operating area is located. Similarly, under the Water Sustainability Act, any of the following whose rights the decision maker considers to be detrimentally affected if the amendment application is granted must be notified under the Water Sustainability Act. And that includes an authorization holder, change approval holder, applicant for authorization or change approval, riparian owner, or a landowner whose land is likely to be physically affected if the application is granted. The definition of major amendment will no longer be used as guidance as to when consultation and notification might be requested for an amendment. The following guidance may be used as considering factors as to when a decision maker might require additional consultation or notification on an amendment application under OGA. If there are new rights holders or landowners of the land on which the operating area is located, consultation and notification might be required. If there were previous unresolved concerns about the original permit, consultation and notification might be required. Similarly, if there is an increase in the area or shift in location, or an increase in the class of the facility. Applicants are encouraged to contact the Commission before they submit an amendment application, just to make sure they're clear about whether any additional consultation or notification is required. I'll be speaking in the next few slides about the content of letters, including the invitation to consult and the notification letter. Before getting into those details, we'll be reviewing some common terminology, most of which is existing already, but there is one new term. That term is respondent. And a respondent is a recipient of a consultation or notification letter who sends a written response to the applicant. This term is used throughout the RCNR. We used to just say a recipient who sent a written response in the old regulation, but now we just use the term respondent. Written response, reply, and submission can get easily interchanged because they seem to be similar. However, they're very distinct in their meaning and how they're used in the regulation. So to recap, the written response is from the respondent to the applicant. The written reply is from the applicant to the respondent, and the written submission is from the recipient to the Commission. For the letter content, the differences in layout of the two regulations is that the old consultation notification regulation had separate sections for a list of items for notification and then a separate list for items for consultation. Now in the new RCNR, there's one list of items required for all letters, notification and consultation, And then there's a list of additional items that need to be included if the letter is for consultation. One of the differences is that currently the notification letter must include a statement that a written response can be provided within 21 days and either advise the person doesn't object or set out reasons why the activity should not be carried out or should be modified. The RCNR has a change to the number of days and simplifies how recipients can respond. So the statement required will now be that a written response can be provided within 30 days by simply stating if there are any concerns and if so, the reasons for those concerns. Note that this applies to both the consultation and notification letter under the RCNR. The second statement, that a written submission can be made to the Commission, is the same. In the existing consultation notification regulation, letter content for consultation only, the requirement is to describe the nature and extent of reasonably foreseeable noise, dust, and odors, and also a description of the order that the activities would be carried out and their timing. Under the RCNR, again for the consultation letter only, the requirement is to describe the nature and extent of reasonably foreseeable noise, dust, light, and odors. Light is the new addition. Also, similar to the existing requirement, the RCNR requires an estimate of the dates that phases will begin and end. Now again, for consultation letters only, the existing CNR requires that the nature and extent of vehicle traffic on oil and gas roads within the consultation distance is included, as well as a statement that within 21 days the recipient can request a meeting. For the RCNR, this is changed to include the anticipated traffic instead of the nature and extent of traffic on oil and gas roads within the consultation distance, and also a statement that the recipient can provide a written request to meet within 30 days of the deemed receipt of the letter. Now we'll turn to the when requirement changes. So when does the RCNR response period start? Under the current regulation, the response period was calculated with reference to when a recipient received a notice, but there was no way to prove exactly when a notice was received. Now this is calculated under RCNR on a knowable date, which is the deemed service date or deemed receive date under section 22(1) of the RCNR. The other change is that there is now a 30-day response period instead of a 21-day response period. We did hear from landowners that 21 days is just simply not enough time in many circumstances, so we've extended that to 30. The other change is that the applicant's obligations around notice stop 30 days after the service date or receipt date. That applies with respect to each recipient. It used to be calculated on a group basis, which made it really difficult to know when it began and started. So this is just meant to be clear for everybody. So to sum it up, the two primary changes to when in RCNR is that the response period is calculated from the date that the letter is deemed received, and the response period has been extended from 21 days to 30 days. So now we'll turn to written reply requirements. If a written response is received, the written reply requirements are triggered as long as that written response was received within 30 days of the deemed service date or deemed receipt date. This is very similar to the existing requirement for written replies. The reply is to include a description of any project revisions based on the concerns expressed by the respondent. It's also to include a summary of the meeting if one was held, and it's also to include two statements. The first is that the written response and written reply will be included in the written report that the applicant submits to the Commission. And second, that a written submission can be made by the recipient/respondent. And just like it is now, the statement is only applicable to new OGA Section 24 applications. So the difference here is that it is required to be sent. The reply is required to be sent if a written response is received within 30 days instead of within 21 days. Now turning to service regulation changes. There's really very few substantive changes here. One is that the mail delivery time has increased from 5 to 14 days. And we were hearing anecdotally from landowners and Indigenous groups that mail was not reliably being delivered within 5 days in the Northeast. So we checked that back with Canada Post and found that 14 days is their posted delivery timeline. So that's what we've included in this regulation. We've also changed methods of service somewhat. First is if a First Nation or local government provides a specific contact or address within the organization, the applicant must deliver specifically to that contact or address. Second, we've expanded the types of electronic transmission that a permit holder or that an applicant can use. So it used to be just email. Now they could also use email or web portal or an FTP if that works for recipients. So here's just a graphical way of showing the change. Really the only change to a deemed service period or deemed receipt period is in the use of registered or regular mail. So it's gone from 5 days to 14 days. And you can see that in red in the top line. So what does all of this mean for applications that are either where consultation and notification finishes just before June 1st or where it's still ongoing as of June 1st when these changes come into effect? Applications submitted before or on May 31st will fall under the service period and response timelines of the current regulation. So that would be a mail delivery time of 5 days and a response time of 21 days. In some cases, an application might be submitted on June 1st or after June 1st, but where the service period and the response period had already ended prior to or on May 31st. In that case, those applications will also fall under the service period and response periods of timelines of the current regulation. This means that Commission review staff will consider the existing consultation notification regulation requirements when completing reviews and moving these applications to a decision, even if they're reviewing it after June 1st. Here is a specific example of what that could look like. So for example, you can see in the first line going across, if an invitation to consult or notice is sent by mail and it's put in the mail on May 5th, the old service period of 5 days will apply, which means that the deemed received day will be on May 10th. At that point, the service period has ended. So it was the service period under the old regulation. Then, because we're still before June 1st, the response period is triggered. It's a 21-day response period, and it runs until May 31st, which is the day before the new regulations come into force. Therefore, the response period is just the old response period of 21 days. And the date that an applicant can submit their application is June 1st. Now there's going to be a second category of applications where the service or response periods are only partially completed as of June 1st. The new timelines will need to be considered if either the service or response period has not ended before June 1st. Depending on where the timelines fall, applicants might need to consider both the consultation notification regulation and the new requirements for consultation notification regulation. Commission staff will consider both when completing reviews to make sure that the appropriate timelines have been applied. Here's an example of how this could play out. So imagine that an invitation to consult or a notice was sent by mail on May 26th. On May 26th, the old service period still applies and it's 5 days, which means that the service period ends on May 31st, which is the day before the changes come into force. That means that on the response period starts on June 1st. And so it will be the new response period of 30 days from the new regulation that applies to this particular application, which means that the date of submission for the applicant, the earliest date, will be July 1st. Here's a second example. If the invitation to consult or the notice is sent by mail on May 27th, it starts out with the 5-day service period from the old regulation, but because when the regulation comes into force on June 1st, we're just on day 4 of the service period, now the new service period kicks in. So the recipients will get the entire 14 days before the letter is deemed received. So the deemed receipt day is now under the new regulation, and it's deemed to be June 10th. And then obviously the new response period applies, which is 30 days, which means the applicant's obligation ends on July 10th, and the date that the applicant can submit its application to the Commission is July 11th. And here's just another way to see how the new timelines work when we put it all together. So if something is served by mail, that's that top row going across the slide, you can see that there'll be quite a change because the service period jumps from 5 to 14 days. And then additionally, we have the response period going from 21 to 30 days, which means that the earliest date an application may be submitted after it's been put in the mail to go to a recipient is calendar day 45. The change is less dramatic, I guess, or less obvious with other methods of service because all of those deemed receipt days and deemed service periods have remained the same. So for electronic transmission, faxing, or leaving in a box or mail slot, got 3 days before the notice is deemed to be received. If it's delivered in person by an agent, then you're deemed to receive it on the day it's delivered. There's no service days. So the only change here would be that the recipient response period has gone from 21 to 30 days. And so we can see that the earliest date an application could be submitted would be on calendar day 34 or calendar day 31, depending on which service method was used. The landowner FAQ and the landowner's information guide will be updated with information about the new RCNR and the new service regulation changes. As mentioned at the outset, this presentation focused on changes between the old regulation and the new. If you'd like a refresher on consultation and notification basics that stayed the same, please check out the webinar titled Consultation and Notification on the Commission's webpage. And you can see the address for that right in the bottom of the third bullet on this slide. If you have further questions, please feel free to reach out to the stakeholder relation group at the Commission.
and their email address is stakeholder@bcogc.ca. Thanks very much, everybody, for taking the time to go through this webinar. Goodbye.